Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. If you're studying law, this case summary is one worth knowing. Cold. Have you ever tried to claim a reward or a deal only to be told you didn't qualify because you weren't thinking about it at the time? In contract law, the case of R.V. Clarke sets a massive precedent about intent. We're going to look at why a man who helped catch murderers was denied a massive reward and what that means for your legal agreements today. Alright, let's start with the real-world problem. This case started with a brutal crime and a desperate government offer that eventually led to a courtroom battle over a forgotten promise. In 1926, the Western Australian government offered a £1,000 reward for information leading to the arrest of the murderers of 2 police officers. This was a unilateral offer made to the whole world, which is common in reward scenarios. Understanding the nature of this offer is the first step in knowing if a contract even exists between 2 parties. Evan Clarke was actually arrested and charged with the murders himself. To clear his own name and avoid the gallows, he gave the police the information they needed to catch the real killers. At that specific moment, his only goal was self-preservation, not the reward money. This distinction between doing something for yourself versus doing it for a contract is vital. After the real murderers were convicted and Clarke was released, he tried to claim the £1,000 reward. The government refused to pay, arguing that he hadn't fulfilled the contract correctly. This is where many people get stuck, assuming that just because they did the work, they're automatically entitled to the pay. During the trial, Clarke admitted that at the time he gave the information, he had forgotten all about the reward. This honest admission became the focal point of the entire case. It highlights a common mistake, assuming your subjective thoughts don't matter as long as the job gets done. Now we move into the core legal question. Does a contract exist if one party doesn't even have the offer in mind when they perform their part? For a contract to be valid, there may want to be a meeting of the minds. Both parties need to be acting in relation to the same agreement. If you perform an act without the offer in mind, the law questions if there was ever a true agreement between you and the offerer. The court had to decide if acceptance of a unilateral offer requires the person to be acting in reliance on that offer. It isn't enough to just happen to do what the offer asked. You may want to do it because the offer exists. This is a subtle but expensive trap in many business negotiations. Usually, the law looks at what a reasonable person would think, objective. But here, Clarke's own testimony about his thoughts, subjective, was used against him. If you admit you weren't acting on a contract, the court will likely take your word for it. Always be careful how you frame your motivations in a dispute. Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. The High Court of Australia eventually made a landmark ruling that changed how we view acceptance in unilateral contracts. The High Court ruled that Clarke couldn't claim the reward. Because he admitted he had forgotten the offer, he wasn't acting in response to it. Therefore, there was no acceptance, and without acceptance, there's no contract. This shows that even if you provide value, you might not get paid without a clear legal link. The court treated Clarke's forgetfulness the same as if he had never known about the offer at all. If you don't know about a deal, you can't accept it. This is a red flag for anyone performing services without a signed agreement or a clear understanding of the terms in place. Justice Higgins famously remarked that Clarke didn't act on the faith of, or in reliance upon, the proclamation. He compared it to a person who finds a lost dog but only realizes there was a reward later. They can't usually claim it retroactively. This is a great framework to use when deciding if you have a right to a payment. Understanding R.V. Clarke isn't just about old history. It's about protecting yourself in modern agreements and avoiding common legal pitfalls. If you're acting on a public offer or a company's promise, document that you're doing so. Send an email or keep a record that shows you're aware of the terms before you start. This prevents a company from claiming you were just doing your job or acting for other reasons. While it might seem unfair that the government didn't pay for the help, contract law is about the agreement, not just the result. Courts prioritize the integrity of the contract over the fairness of the outcome. Don't assume a court will save you just because you did something helpful. If you're involved in a high-value dispute over a reward, commission, or unilateral promise, call a qualified legal professional. These cases often hinge on small admissions like Clarke's. A pro can help you frame your intent correctly and check the specific codes in your jurisdiction. That's the practical version of what matters most in RV Clarke. The big idea is to understand that your intent and your knowledge of an offer are just as important as the work you actually do. Don't leave your compensation to chance. If this helped you understand the complexities of contract law, like and subscribe to Law Conquer for more practical guides that help you navigate legal principles and protect your interests with more confidence. Remember, this is a summary for study purposes. Always read the full case. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.